Hello. Welcome to the NAUPA Fundamentals of Unclaimed Property Reporting for Holders training. I'm glad you're here to learn about the exciting topic of unclaimed property. Let's start with the basics. What is unclaimed property? The definition of unclaimed property is any funds or other intangible property that have remained unclaimed by the owner for a specified number of years. Generally, it means if you're acting as a fiduciary, the funds can become abandoned and reported as unclaimed property. Some states also include tangible property held by a bank in a safe deposit box as unclaimed property. Let's go through some definitions that will be used throughout the seminar today and that you will commonly hear in the context of unclaimed property. You'll often hear the word escheat used to refer to unclaimed property, but that's not technically correct. Escheat means the state would take ownership of the property, where in reality it maintains a custodial relationship to the property. The state never takes ownership, simply holding the property for the rightful owner or heir in perpetuity. Another common term you'll likely hear is holder. A holder is an entity who is in possession of property belonging to another or is indebted to another on an obligation. If you're a company, you're likely holding unclaimed property. An owner is a person who has a legal right or equitable interest in the unclaimed property. Due diligence, which will be talked about in more detail in the next seminar, is the use of reasonable and prudent methods to locate apparent owners of unclaimed property. Property becomes abandoned at different rates. That rate is known as the dormancy period, or the amount of time an owner does not take action on his or her property and it becomes unclaimed. This is typically 3 to 5 years. Some common types of unclaimed property would be, say, your payroll checks, accounts payable, refund checks, cashier's checks, insurance proceeds, stocks and mutual funds, royalties, money orders, and so on. Now that we better understand what is unclaimed property, let's take a look at why these laws exist and who benefits from them. We're going to talk through these two questions. The primary group of people that benefit from an unclaimed property law would be the owner, the person who had the property to begin with. Unclaimed property laws are consumer protection laws. As we discussed, even though states have custody of the property, they don't have ownership. They hold it in custody to provide a central location for owners to search for their lost assets. The work to find owners using in-person and digital outreach. Each program maintains an online database that you can search and start a claim online in an easy couple steps. Most states also participate in the national searchable database missingmoney.com. In almost all states, there's no limits on when the owner or rightful heir can make a claim, and states maintain the records indefinitely. Also, holders benefit from unclaimed property laws because the obligation is removed from the company's books and records forever. Once it's reported, a holder is required to retain records for a certain amount of time, but they're not required to pay out that money. The state takes over that responsibility and the custody of that money until the owner is paid. The liability is transferred to the state and the holder is indemnified. Finally, all citizens benefit from unclaimed property laws. Any excess funds that a state has and is holding could be used for the benefit of citizens. In most states or in many states, money is transferred to the general fund for the use of the legislature. In some states, there are dedicated funds that are appropriated. Some examples include Florida with the State School Fund. In Virginia, there's a literary fund. In Oregon, there's the Common School Fund Property Program. You can see that excess funds, even though the state may be holding money that hasn't been claimed by someone, can be used for the good of others. Let's now talk about some myths in unclaimed property, some things that could be misleading. One is thinking that my organization does not have any unclaimed property. That's likely not true. Practically all companies have an unclaimed property liability. Any entity in possession of property belonging to another is potentially a holder of unclaimed property. That being said, it's not proof that the company is not holding unclaimed property, but it's likely that if you're issuing a check or holding money for another person, that you could potentially have unclaimed property and definitely need to review your records on a yearly basis. One other myth that is out there says unclaimed property reporting is voluntary. Whereas most states have a voluntary free filing option, reporting of unclaimed property is not voluntary. It is required in all state statutes. Some residual risks that are out there outside of the unclaimed property law would be that, say, failure to report nor admit unclaimed property liability could result in a material misstatement under a FAS 5, which is a financial accounting standard. There's also risk for litigation, and a risk that there could be a violation of the Sarbanes-Oxley Act of 2002. These are all residual risks, not necessarily applied to the Unclaimed Property Act itself. But if a holder chooses not to report unclaimed property, they could have a risk of a state auditing their books and records or also assessing interest and penalties for noncompliance. Another myth is thinking that my organization is only required to report to our state of domicile or to states in which we actively conduct business. The U.S. Supreme Court says otherwise, and in several cases, have set up priority rules for reporting on unclaimed property. In three such cases, one in 1965, Texas versus New Jersey, they set up the primary and secondary rule for reporting unclaimed property. In 1972, that ruling was affirmed again in the Pennsylvania versus New York case, whereas in the Texas case, it talked more to oil and gas mineral royalties as being reportable to the correct venue. The Pennsylvania versus New York case involved money orders, traveler's checks, and other bank-related written instruments. Then again, in 1994, in the Delaware versus New York case, that case involved more about securities-related property or stocks. The opinion out of that case upheld the other two cases as well. So, what are these priority rules for reporting on unclaimed property that came out of these cases and subsequent U.S. federal law? The primary rule for reporting unclaimed property is that unclaimed property should be reported to the state of the owner's last known address. The secondary rule, if there is no address for the owner or the owner is unknown, unclaimed property should be reported to the holder's state of domicile, which was clarified to be the state of incorporation in most cases. In 1974, Congress added in a transaction rule where they updated Title 12, Section 2501 of the U.S. Banking Code. Now, that transaction rule, or what some in the unclaimed property sphere call the third priority rule, is that in a subset in bank-related properties should be reported to the state where the transaction occurred. What are the holder's responsibilities by law? What is a holder required to do? There is a list of 4 items that is a good checklist to work through. If you're taking notes, write these 4 items down so that you add this into your yearly procedures. First, you will review your books and records to identify potential unclaimed property. Then you perform due diligence, which is a mandatory step by law to send notice to an owner before it's sent to an unclaimed property agency. We'll discuss this in more detail in the next video. Then report and remit to the appropriate states, submitting your report in a proper format and making payment to the appropriate states. State laws can vary, so you'll need to review the specifics of each state you're reporting to. While the history of unclaimed property finds its roots in historical England, most states patterned their law from a uniform Unclaimed Property Act. There are 4 such acts. The original was enacted in 1954 by the Uniform Law Commission, with revision in 1981, 1995, and most recently in 2016 as the revised Uniform Unclaimed Property Act. While we strive for uniformity, some common differences might include how long to hold a property before it becomes abandoned and reportable. Due diligence requirements could also change from state to state. States typically have spring or fall reporting deadlines depending on state and the type of property. Some states, the reporting deadline is July 1, some states it's November 1, some states it's May 1. Make sure you're confirming how each state requires reports to be submitted. Most are done through an online portal. You can find links to state reporting information at unclaimed.org/report. How do you identify potential unclaimed property? Reviewing aged accounts payable, uncashed checks, or matured deposits to reveal potential unclaimed property. Accounts with no recent transactions or customer contact might indicate dormant or abandoned property. Undeliverable mail, particularly certified letters or notices related to financial accounts, can signal the need for further investigation into potential unclaimed property. Detailed state reporting information is available on unclaimed.org/report. This concludes Part 1 of Unclaimed Property Fundamentals. Thank you for your participation.